Hello everyone. In this presentation, an attempt would be made to explain the scope of various clauses of Article 15 of the Constitution with the help of decided cases. While Article 14 deals with the principle of equality in general, Article 15 explains and elaborates the implication of equality before law. Certain classifications are prohibited under Article 15, though they can be justified under Article 14, and certain classifications are required to be made under Article 15, though they may not always be justifiable under Article 14. The implication of the principles of equality before the law and equal protection of the laws to all spheres of life outside public employment are explained and elaborated under Article 15. Article 15 consisted of three clauses originally, to which three more have been added by the Constitutional Amendment Acts. Clause 1 of Article 15 prohibits the state from discriminating against citizens on grounds only of religion, race, sex, caste, place of birth, or any of them. The right guaranteed in Clause 1 is a right in personam conferred on a citizen as an individual and is available against his being subjected to discrimination in the matter of rights, privileges, and immunities pertaining to him as a citizen generally. Discrimination involves an element of prejudice or unfavorable bias, and it is in that sense that the expression has to be understood. If prejudice is disclosed and is based on any of the grounds mentioned in Article 15, the law will be struck down as violative of the constitutional prohibition unless it is saved by one or the other provisos to that article. In Vichaka versus State of Rajasthan, the Supreme Court held that sexual harassment of women at workplace amounts to discrimination on the ground of sex, which is violative of Articles 14, 15, and 21 of the Constitution, and issued guidelines to ensure the prevention of sexual harassment of women. In National Legal Services Authority versus Union of India, the Supreme Court held that the expression sex in Article 15 is not limited to biological sex of male or female, but includes transgenders, and hence it prohibits discrimination based on gender identity. The court also held that the transgenders have been denied rights under Articles 15.2 and 15.4, and they are legally entitled and eligible to get benefits available to socially and economically backward classes for admission in educational institutions. In Karma Dorji versus Union of India, the Supreme Court held that racial discrimination faced by the people of northeastern states of India is in violation of Article 15.1 and issued directions to the central government and state government to strictly comply with the report of Base Barua Committee. This committee was set up to look into the concerns of people of the northeast living in other parts of India. The article does not mention residence, and hence discrimination on the ground of residence is not barred. Now, coming to Clause 2 of Article 15, it extends the idea of non-discrimination and provides that no citizen shall, on the grounds only of religion, race, caste, sex, place of birth, or any of them, be subjected to any disability, liability, restriction, or condition with regard to access to shops, public restaurants, hotels, and places of public entertainment, or the use of wells, tanks, bathing ghats, roads, and places of public resort maintained wholly or partly out of state funds or dedicated to the use of the general public. While the right conferred by Clause 1 is available against the state only, the right under Clause 2 is available against private persons also. The prohibition under subclause B of Clause 2 will apply only if these places are either maintained wholly or partly out of state funds or dedicated to the use of general public. A private well or a tank does not come within the meaning of this clause. Places of public resort are places which are frequented by the public, like a public park, a public road, a hospital, etc. Now, Article 15.3 empowers the state to make special provisions for the women and children, notwithstanding non-discriminatory clauses 1 and 2 of Article 15. Clause 3 enacts that nothing in Article 15 shall prevent the state from making any special provision for women and children. Reading clauses 2 and 3 together, it will follow that while there can be no discrimination in general on the ground of sex, special provisions in the case of women and children are permissible. Thus, it would be no violation of Article 15 if institutions are set up by the state exclusively for women, or places are reserved for women at public entertainment or in public conveyances. In Government of Andhra Pradesh versus P.B. Vijay Kumar, the Supreme Court gave a new dimension to Article 15.3 by holding that reservation for women in state employment is also permissible under that provision, notwithstanding separate provision in this regard under Article 16. In this case, an Andhra Pradesh government rule which provided for preference for women in jobs better suited for them, preference up to 30% for women in jobs for which they are equally suited with men, and direct recruitment to posts reserved exclusively for women was upheld. The court held that Article 15.3 was wide enough to cover any special provision for the women, including reservation in jobs. Article 16 does not come in the way of setting reservations. The two articles must be harmoniously construed. Both of them aim at egalitarian society and authorize special provisions for the upliftment of its weaker sections. The language of Clause 3 is in absolute terms and does not appear to restrict in any way the nature and ambit of special provisions which the state may make in favor of women and children. In Joseph Shine versus Union of India, the Supreme Court unanimously struck down Section 497 IPC, punishing adultery, and Section 198 CRPC, pertaining to filing of a complaint against adultery, as unconstitutional, as it violates Article 14 and Article 15.1 and is not saved by Clause 3 of Article 15. The court held that Section 497 treats women as subordinate to men by laying down that when there is connivance or consent of man, there is no offense. This provision treats married women as property of their husbands and arbitrarily denies her agency to complain against adulterous behavior of her husband. Equally arbitrary is the fact that Section 497 IPC does not visit an extramarital relationship by a man with an unmarried woman or a widow with penalty. The Supreme Court in Hotel Priya versus State of Maharashtra, disapproving gender-based stereotypes, held that the condition imposing a gender cap as to the number of women or men who can perform in orchestra and band in licensed bars is unconstitutional, as it comes within the prohibition of Article 15 Clause 1 and is not saved by Clause 3 of Article 15. Now, coming to Clause 4 of Article 15, it was inserted by the Constitution First Amendment Act 1951 as a result of the decision of the Supreme Court in State of Madras versus Chempakam Dorai Rajan. This is another enabling provision empowering the state to make special provisions for the advancement of any socially and educationally backward classes of citizens or for the scheduled castes and scheduled tribes. In Dorai Rajan's case, the court struck down the communal GO of the Madras government, which, with the object to help the backward classes, had fixed the proportion of students of each community that could be admitted into the state medical and engineering colleges. Although the directive principles of state policy embodied in Article 46 of the Constitution lays down that the state should promote with special care the educational and economic interests of the weaker sections of the people and protect them from social injustice. The court held that the directive principles of state policy have to conform to and run as subsidiary to the chapter on fundamental rights. Now, by inserting Clause 4, the state is empowered to make special provisions for the advancement of socially and educationally backward classes of citizens or for scheduled castes and scheduled tribes. Such provisions include reservations or quotas and can be made in the exercise of executive powers without any legislative support. But there are two contentious issues in the application of Article 15.4, which are the determination of backward classes and the extent or quantum of the reservation. Now, so far as the scheduled castes and scheduled tribes are concerned, they are defined under clauses 24 and 25 of Article 366. No such definition of backward classes has been given anywhere in the Constitution. The courts reviewed state decisions and arrangements in this regard to ascertain if proper criteria for determining the backward classes have been adopted. In M.R. Balaji versus State of Mysore, R. Chitralekha versus State of Mysore, State of AP versus P. Sagar, and Triloki Nath versus State of Jammu and Kashmir, the Supreme Court held that the caste of a group of persons cannot be the sole or even predominant factor, though it may be relevant for ascertaining whether a particular class is backward or not. Backwardness must be social and educational, which ultimately would be because of poverty. But in P. Rajendran versus State of Madras, A. Periyakaruppan versus State of Tamil Nadu, and State of AP versus USV Balram, the Supreme Court upheld the test of backwardness, which is predominantly based on caste. Again, in State of UP versus Pradeep Tandon, the Supreme Court emphasized that the backwardness contemplated under Article 15.4 was both social and educational, and the socially and educationally backward class of citizens were groups other than the groups based on caste. The traditional unchanging condition of citizens could contribute to social and educational backwardness. The place of habitation and its environment could be a determining factor in judging the social and educational backwardness. In Jayashree versus State of Kerala, the Supreme Court held that in ascertaining social backwardness of a class of citizens, it may not be relevant to consider the caste of a group of citizens. Caste cannot be made the sole or dominant test, as social backwardness is in the ultimate analysis the result of poverty to a large extent, though social backwardness which results from poverty is likely to be aggravated by the considerations of caste. This shows the relevance of both caste and poverty in determining the backwardness of the citizens. But neither caste alone nor poverty alone can be the determining test of social backwardness. In K.C. Vasant Kumar versus State of Karnataka, the Supreme Court was asked to give clear guidelines on this issue. But the 5 judges of the Constitutional Bench of the Supreme Court expressed 5 separate opinions on the question. From the divergence of opinions, it can be concluded that except Justice Desai, who considered poverty as the only test of backwardness, all others considered caste also a relevant consideration, at least at that stage of the Indian society. Once again, the question was considered by a 9-judge bench of the Supreme Court in Indra Sahani versus Union of India, that is the Mandal Commission case. In this case, the constitutional validity of 2 office memoranda of central government, one reserving 27% of vacancies in civil posts and services under the Government of India to be filled by direct recruitment from socially and educationally backward classes, and the other reserving 10% vacancies additionally for other economically backward sections of the people who were not covered by any existing schemes of reservation, was challenged. By a 6-3 majority, the court upheld the first memorandum, but invalidated the additional 10% reservation by the second one. The court held that caste was not an essential factor for determining the social and educational backwardness, and it is not necessary that social and educational backward classes should be similarly situated as scheduled castes and scheduled tribes. Within social and economically backward classes, classification between the backward and more backward is permissible. To maintain the cohesiveness and character of a class, the creamy layer can and must be excluded from SEBCs. In Article 15.4, the accent is on both social and educational backwardness. The court also held that the economic criterion alone cannot be the basis of backwardness, although it may be a consideration along with or in addition to social backwardness, and suggested creation of a body at the state and central level to look into complaints of over and under inclusion and revise the list of socially and economically backward classes periodically. Backward classes commissions have accordingly been set up by the center and the states for periodical revision of SEBCs and for excluding creamy layer from among them. Where standard set up for determining the creamy layer is unreasonably high, it has been invalidated, and where any government failed to appoint a commission or exclude creamy layer, directions have been issued compelling it to do so. With this decision, caste has become an important or even sole factor in determining the social backwardness, but poverty alone cannot be the sole factor. Coming to the question of quantum of reservation, in M.R. Balaji versus State of Mysore, the validity of Mysore government order reserving 68% of the seats in the engineering and medical colleges and other technical institutions in favor of backward classes, including the scheduled castes and scheduled tribes, was challenged. The Supreme Court held that the reservation of 68% of seats was plainly inconsistent with Clause 4 of Article 15. A special provision contemplated by Article 15.4, like reservation of posts, must be within reasonable limits, and generally speaking and in a broad way, a special provision should be less than 50%. How much less than 50% would depend upon the relevant prevailing circumstances in each case. In Devadasan versus Union of India, a rule of the central government which actually reserved only 17.5% of the posts in central services for the SCs and the STs, but provided for carrying forward of their unfilled quota in the absence of availability of suitable candidates to the next 2 succeeding years, was invalidated on the ground that accumulation of 17.5% in 3 years would come to 54%, and in the instant case it had come to 64% because out of 45 vacancies, 29 went to the reserved quota. Both these cases were decided on the argument that Article 15 Clause 4 was an exception to the general rule embodied in Clause 1 of Article 15 as well as in Article 14. The general rule required that in the interest of the community as a whole, admissions to the institutions of higher learning or employment within the state must be made on merit in order to ensure an efficient society and administration. An exception could not be so construed as to eat away or even substantially dilute the general rule. In state of Kerala versus N.M. Thomas, because of an exemption given to the scheduled castes and scheduled tribes for passing a departmental test for a number of years for the purpose of promotion from lower division to upper division clerks, in a particular year, out of 51 posts, 34 had gone to the candidates belonging to the SCs and STs. The court upheld the rule providing for exemption and emphasized that Clause 4 of Article 15 was an emphatic assertion and direction to the state to take effective affirmative steps to enforce the concept of equality as laid down in Articles 14 and 15.4. To bring about that equality, state could make reservations to any extent, and certainly it could do that in order to provide adequate representation to the scheduled castes and scheduled tribes in higher education as well as state employment. In Akhil Bharatiya Soshit Karmachari Sangh Railways versus Union of India, the Supreme Court insisted that the quantum of reservation has to be seen in the context of overall representation of the scheduled castes and scheduled tribes and not in a particular year. In Chakradhar Paswan versus State of Bihar, the court, however, held that single post in any cadre could not be reserved either at initial stage or in filling up of a future vacancy. In Indra Sahani versus Union of India, upholding the validity of a total of 49.5% reservation, the Supreme Court held that barring any extraordinary situations, reservation should not exceed 50%. The 50% limit does not include those members of SCBCs who get selected on their own merit. They are entitled to get adjusted against the open category. But this limit applies only to reservations and not to exemptions, concessions, and relaxations. For the application of 50% rule, a year should be taken as the unit and not the entire strength of the cadre, service, or the unit, as the case may be. So long as this limit is observed, carry forward rule is permissible. The court has clearly held that clause 4 of Article 15 is not an exception to clauses 1 and 2 of Article 15 or to Article 14. It is rather the means of achieving the right to equality enshrined in those articles. It is an emphatic reference to the affirmative action which the state may adopt to improve the conditions of the disadvantaged members of the backward class of citizens. However, they are exhaustive of all reservations, concessions, relaxations, and exemptions for SEBCs. In Valsama Paul versus Cochin University, the Supreme Court held that voluntary mobility to reserved class through intercaste or interreligion marriage or adoption would not entitle the lady or adoptee to claim reservation under Article 15.4 owing to the advantageous start in life availed by him or her. In Preeti Srivastava versus State of Madhya Pradesh, a constitutional bench of the Supreme Court, by a majority of 4:1, invalidated admission criteria for the scheduled castes, scheduled tribes, and SEBCs, which provided lower percentage of marks for admission to postgraduate medical courses for these classes than provided for the general category. The court relied upon the relationship between clause 4 of Article 15 and Article 335 relating to super specialty jobs and efficiency of administration. The dissenting judge did not agree with the majority on this issue. The Constitution 82nd Amendment Act 2000 eroded the basis of the court decision insofar as it added a proviso to Article 335 providing for relaxation in qualifying marks or standards of evaluation to the scheduled castes and the scheduled tribes. In E.V. Chinnaya versus State of Andhra Pradesh, subclassification of SCs made by the AP SCs Rationalization of Reservations Act 2000 was challenged. The Supreme Court held that though reservation in educational institutions under clause 4 of Article 15 to a backward class is the prerogative of the state concerned, with an object of providing opportunity for advancement in society, it is not open to the state to subclassify a class already recognized by the Constitution and allot a portion of the already reserved quota among the state created subclass within the list of scheduled castes. Such subclassification or microclassification would violate Article 14 of the Constitution. Now coming to clause 5 of Article 15, it provides for reservation of seats to SCs, STs and SCBCs in educational institutions including private educational institutions, whether aided or unaided by the state, other than the minority educational institutions referred to under Clause 1 of Article 30, notwithstanding Articles 15(1) and 19(1)(g). This clause was inserted by the Constitution 93rd Amendment Act 2005 and is similar to Clause 4 of Article 15 in the sphere of higher education. The operation of this clause is dependent on relevant legislation to be passed by Parliament and state legislatures. In Ashoka Kumar Thakur versus Union of India, the Supreme Court held that Clause 5 of Article 15 is valid to the extent that it permits reservation for socially and educationally backward classes in state or state-aided educational institutions, subject to the exclusion of creamy layer from other backward classes. Further, the court held that the exclusion of minority educational institutions from Clause 5 of Article 15 is also valid. However, the question of validity of inclusion of private unaided institutions within the purview of Clause 5 was left open for a later occasion. In Indian Medical Association versus Union of India, the Supreme Court held that given the absolute necessity of achieving the egalitarian and social justice goals that are implied by the provision of Article 15(5) and the urgency of such a requirement, they are not a violation of the basic structure of the Constitution. In P.V. Indiresan versus Union of India, the Supreme Court clarified that the maximum cutoff marks for OBC candidates are to be 10% below the cutoff marks of the general category candidates. The Supreme Court further clarified that cutoff marks of OBC candidates are to be computed with respect to minimum eligibility marks for course concerned or qualifying marks in entrance examination concerned and not with respect to marks secured by last candidate admitted under the general category to the course concerned. In Pramati Educational and Cultural Trust versus Union of India, where the validity of Clause 5 of Article 15 of the Constitution was challenged, the Supreme Court held that the object of Clause 5 of Article 15 was to enable the state to give equal opportunity to the socially and educationally backward classes of citizens or to the SCs and STs to study in all educational institutions and hence is not an exception or a proviso overriding Article 15 of the Constitution, but is an enabling provision to make equality of opportunity promised in the preamble of the Constitution a reality. In Neil Aurelio Nunes versus Union of India, the Supreme Court held that special provisions, including reservations made for the benefit of any class, are not an exception to the general principle of equality, but are a method to ameliorate the structural inequalities that exist in the society, without which true or factual equality will remain illusory. Thus, Articles 15(4) and 15(5) are nothing but a restatement of the guarantee of the right to equality stipulated in Article 15(1). Coming to Clause 6 of Article 15, it was inserted by the Constitution 103rd Amendment Act 2019, which consists of two subclauses. Subclause A empowers the state to make special provisions for economically weaker sections whose family's gross income is below 8 lakh rupees and who are not covered by clauses 4 and 5, that is, they do not belong to SC, ST or SEBCs. Subclause B empowers the state to make special provisions for the above stated class relating to reservation of seats both in public and private educational institutions, whether aided or unaided by the state, other than in the minority educational institutions referred to in Article 30, Clause 1. The reservation under Subclause B should be a maximum of 10% of the total seats in each category and is in addition to the existing 50% as held by the Supreme Court in Indra Sahani case. The two important differences between Articles 15.5 and 15.6 are: under Article 15.5, law has to be enacted by the Parliament or the state legislature for exercising the powers given under the clause. Under Article 15.6, no such condition is specified and special provisions can be made even by exercising executive power. The indicators of backwardness under Article 15.6 are confined to economic disadvantage alone, to the exclusion of indicators of social and educational backwardness under Article 15.5. Article 15.6, apart from providing quota for economically weaker sections in educational institutions, also has an enabling clause which empowers the state to make special provision for the advancement of economically weaker sections of citizens other than the SCs, STs, and SCBCs, even beyond the domain of education and employment. The constitutional validity of Clause 6 of Article 15 was challenged in Janhit Abhiyan versus Union of India. The Supreme Court held that economic backwardness is a valid criterion for reservation or compensatory discrimination, and reservation to deal with economic disadvantage has the sanction of the Constitution. As the goal of the preamble is to secure to all its citizens justice, social, economic, and political, deprivations arising from economic disadvantages have to be addressed by the state to achieve the goals of an egalitarian society and social, economic, and political justice. The court therefore held that affirmative action on the basis of economic criteria for the purpose of Article 15 is permissible and does not violate the basic structure of the Constitution. Thank you.